Imagine you planned ahead of time and established a trust to protect your assets for your family, pass on the legacy you worked your whole life for, a plan to qualify for Medicaid so that that government program pays for medical care instead of you. But when you are in a nursing home 10 years later, because your trustee's lack of knowledge, Medicaid deems you ineligible and penalizes you. Then, you must find the private funds to pay for the expensive care needed. Here is a scary example based on true events of what happens when your trustee fails. In 2009, Mr. Lookahead had retained an attorney and established an irrevocable trust. He knew that the cost of a nursing home can be over $100,000 a year. Mr. Lookahead placed his assets in the irrevocable trust and retained a life estate in the home. Unfortunately, Mr. Lookahead and the trustee did not know if the house was ever sold. Mr. Lookahead would need to receive the value of the life estate at the time of the sale or be penalized by Medicaid. Still, the home was sold in 2017 and the proceeds placed into the trust. Mr. Lookahead was not given the $91,000 value of his life estate at the time of the sale. In January 2019, 90-year-old Mr. Lookahead required assistance taking care of himself and decided to move into a nursing home. The trustee panicked about having failed to give Mr. Lookahead the value of his life estate and quickly transferred $85,000, an incorrect sum, from the trust into Mr. Lookahead's personal bank account. The following month, Mr. Lookahead moved into a nursing home and applied for Medicaid. Medicaid rejected his application. Again, Mr. Lookahead retained an attorney, this time to petition Medicaid for a fair hearing. At the fair hearing, Mr. Lookahead argued that the irrevocable trust did not allow him to receive either income or principal from the trust, that the trustees were unaware of the requirement that he receive the value of his life estate at the time the home was sold, that the trustee immediately paid him $85,000 from the trust for the value of the life estate when the trustee became aware. The trustee acted as such to avoid Medicaid from treating the transfer as an improper uncompensated transfer, which would cause a penalty period. The fair hearing officer rejected Mr. Lookahead's arguments and found that he had excess resources of $624,000, the total value of the trust. The hearing officer further found that the trustee had broken the rules of the trust that prohibited a transfer of money to Mr. Lookahead by partially revoking the irrevocable trust and evading the principal of the trust for the benefit of Mr. Lookahead. This invasion of the principal to pay the life estate made the remaining principal qualify as a resource available to Mr. Lookahead. As a result of his trustee's uninformed action, Mr. Lookahead or his family will have to spend private funds on nursing home care. Mr. Lookahead's foresight into Medicaid planning failed because of the actions of an uninformed trustee. If you or a loved one anticipates expensive medical costs and wish to preserve his legacy, contact us, ReYes Law, where we will make sure that you and your trustee understands what is a proper and improper transfer. We will inform and educate you about your options, thereby empowering you with advice. Call us for a free consultation at 646-577-9022 or visit us at www.estateplanningreyes.com.